The last video gave a quick overview of how Jack Daniels limits the potential reach of the Rogers test. Now, Jack Daniels was the first time the Supreme Court took up the question of the Rogers test. Why now? The test had been in use for over 30 years without any concern from the justices. So what's different here? Well, here's Justice Kagan, who ultimately authored the Jack Daniels opinion from the oral argument.
Whether the Rogers test gets the question exactly right, I think you're sort of leagues away from that. This is a standard commercial product. This is not a political T-shirt. It's not a film. It's not an artistic photograph. It's nothing of those things. It's a standard commercial product. I don't see the parody, but, whatever. You're using this, as your complaint says, as your registration on the other product say, as the placement of your hang tag says. You're using it as a source identifier. It seems like just not a First Amendment Rogers kind of case.
So there are two ideas here. First, that this is just a, quote, ordinary commercial product. And second, and the ultimate basis of the court's opinion, that VIP was using its design as a trademark. It wasn't just art. So let's start with the commercial product distinction. What does it mean? Sure, some uses are more obviously works of art than others, but even mere commercial products have design elements and artistic works are bought and sold in commerce. Can we really distinguish the two? Bennett Cooper, VIP's counsel, gave the example of a T-shirt.
The distinction between utilitarian goods and expressive works is a non-existent standard. Your Honor gave as an example a T-shirt. T-shirt, people buy them in order to not get caught up with public nudity. They are functional utilitarian goods, but they may also bear a message. Whether it's a hat or a hat, we all know can become political symbols, or a T-shirt or a coffee mug.
Now, Justice Kagan nonetheless insisted on a distinction between the political T-shirt and a chew toy. While there may be hard cases, she claimed, this is not one of them.
Okay, a dog toy, I'm just going to say, is a utilitarian good. Yeah, there might be some hard cases. I actually don't think that the political T-shirt is a very hard case. It says something, it's making a point. But dog toys are just utilitarian goods, and you're using somebody else's mark as a source identifier, and that's not a First Amendment problem.
And Your Honor, if we changed the hypothetical and we said, okay, put on the hang tag, not for use with real dogs, and it was sold purely as a collectible, because that's what the testimony was, that they intended that this was in part be a collectible from the graphic designer who worked it up. Then it would not be a utilitarian good. It would be soft sculpture in copyright terms, and it would be an art piece. It doesn't matter whether you use it with your dog or you put it on a shelf, as I plan to do, and laugh at it from time to time. It is still an expression. And what Jack Daniels is upset about is not the utilitarian good. They're upset about the speech that's born on it.
Now, I think a big part of what's going on is not only the idea that the toy is a mere commercial product, but also that it is a merchandised version of the Jack Daniels marks. And courts have a really strong intuition that these markets belong to trademark holders, and put that in scare quotes. And however funny or not the VIP toy is, a big part of its appeal is its evocation of Jack Daniels. Stated another way, the product is a reference to Jack Daniels that is sold as merchandise. In her argument, Lisa Blatt made this connection directly.
In the Jack Daniels case, Jack Daniels makes dog products and sells licensed merchandise like hats and bar stools and what have you in the same markets that Bad Spaniels was selling its dog toys.
In other words, Jack Daniels claims that the merchandising market for the Jack Daniels term should belong to Jack Daniels alone. And note that in an ordinary trademark suit, product proximity matters a lot. That is, the fact that the chew toy is in a different market as the whiskey should make consumer confusion less likely. But if the relevant market is trademark merchandise, if that's its own market, then so much the better for Jack Daniels. But perhaps because of the impossibility of drawing a line between expressive works and commercial products, the final opinion rests on the second distinction drawn by Justice Kagan. The notion that unlike others who were protected by the Rogers test, VIP was engaged in a trademark use. On this view, Rogers does not apply because VIP was using the challenged design as a mark, that is, as a source identifier. And recall, Justice Kagan made this point.
You're using it as a source identifier.
Now, the question of what is a trademark use can be controversial, But the court seems to have a common sense view about the question. They seem to think that it's a trademark use when the mark appears where one would normally expect to see a trademark on a product, or as the name of a brand or service. So Barbie as the brand name of a doll is a trademark use, but the song Barbie Girl is the name of a song and not the source of a song. So is that really clear? It's going to take some litigation to know where the line actually ends up, and this case shows some of the difficult questions involved, even though the court takes it as almost self-evident that VIP used its parody of Jack Daniels as a mark. To be sure, VIP did a lot to foster that impression. It claimed trademark rights in the Bad Spaniels mark and, more importantly, its design. But this likely stemmed from VIP's desire to protect its design as merchandise, not as a source identifier. Now, why is that? VIP wasn't trying to sell people on the notion that the appearance of the Bad Spaniels toy was a source indicator. Rather, the toy's selling point is that it is pleasurable to have a chew toy that looks like, or parodies, or evokes, or reminds one of, a bottle of Jack Daniels whiskey. Likewise, VIP's product did not appear on the shelves of liquor stores, where the Jack Daniels trade dress does indeed identify and distinguish its brand from competing whiskeys. So at oral argument, VIP's counsel tried to clarify how VIP was quote-unquote using the trademarks at issue. Cooper distinguished VIP's Silly Squeaker's mark from the term Bad Spaniels, the graphic of the dog, and the total design of the chew toy. Only the first one of those is a straightforward source-identifying mark.
We have argued throughout the case in the district court and in the Court of Appeals that neither Bad Spaniels nor the label and the appearance on the toy are designations of source or function as a trademark.
But some of your other toys are registered trademarks, aren't they? Doggy Walker is registered. Those Paros is registered.
Only the standard character mark, what used to be called the type mark, only that name, not the parodic image. And Jack Daniels has made clear in this case that they don't consider Bad Spaniels to be infringing. It's the totality of the whole look.
This is the very same argument that critics of the merchandising right make all the time. When people buy Boston Red Sox baseball caps, the B is the object of desire, not a designation of source. For the most part, courts don't buy that, and they protect merchandising interests nonetheless. Now, just so here, the only way to call uses like VIP's a trademark use is if merchandising is part of trademark law, and it seems like the Jack Daniels court says, yeah, it kind of is. Now, the final opinion brushes over all of this. It collapses VIP's various possible permutations of what Bad Spaniels means, a source-identifying name, a dog graphic, either or both as component parts of a toy design, and finally as a unified whole, into one bundle that it labels to be a trademark use. The opinion does not pause to distinguish among these components and consider, as Cooper was trying to encourage them, which of these uses are trademark uses, and which of these uses, if any, plausibly infringe the trademark rights of Jack Daniels. The court's approach only makes sense if it sees merchandising uses as trademark uses. That is, if all of VIP's uses count as source identifying given the merchandising context. Now, obviously, that's not going to be a favorable conclusion for those of us who are opposed to the use of trademark law to protect merchandising interests, but that seems, to my mind anyway, pretty clearly what the court is doing. Thanks for watching.